Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefields of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. We are deep in December. Actually, I am leaving tonight for the North Pole. You might be interested to know that. We go to the North Pole every year, and we'll be taking some new guests to the North Pole tonight on the Amtrak leaving out of Old Sacramento. So we have quite an adventure this evening. We're going on the Polar Express, so it will be quite incredible, I think. They also serve the best chocolate chip cookies you've ever had. Okay, anyway, we got to talk about another new law for 2026. This is SB 642. Now, let me give you some background before we jump in. Pay transparency has become a very important issue, not only in California, across the country over the last couple of years. Pay transparency is all about making sure we are paying folks fairly for their work. And it's a comparison law. So when we talk about pay transparency, we're talking about paying people fairly. So making sure that when somebody performs the same or similar work as a coworker, they're getting paid about the same. And there are a lot of provisions and a lot of requirements that different states have. In California, we have had a number of laws that have passed over the last several years that require, for example, if you have 15 or more employees, you have to post a pay scale, and you have to make a pay scale available to your current employees and to applicants who request them. So there's a lot going on here. There's also reporting requirements if you're a larger employer in California regarding how much you're paying your employees and in what roles. Again, the effort being, or the goal being, to create a situation where we can start addressing the pay gap, which is very pronounced for people of color and for women. So that is the goal, and that's what we're looking at. And the California legislature has been very active in this area. So on October 8th, 2025, our governor, Gavin Newsom, signed SB 642. And what it does is it sets the statute of limitations for claims that relate to our pay transparency requirements at 3 years. But there's what we call a 6-year look back period, which we'll talk about. And importantly, very importantly, this new law gives us more information about the pay scale that employers must disclose in their job postings. It talks about a good faith estimate of the pay scale, and it also expands the definition of wages to include all forms of compensation. So bonuses, stock options, that sort of thing. Okay. Now, SB 642 will take effect on January 1, 2026. As some of you may recall, in 2022, the California legislature enacted a number of other pay transparency requirements as part of our state's Equal Pay Act. Remember, there are also federal laws in this area. That law in 2022, as I mentioned earlier, mandates that employers with 15 or more employees include a pay scale for a position in their job postings, and then, of course, also to employees for their current position upon request. Now, SB 642 amends those requirements and makes a number of important changes. First of all, it revises the definition of pay scale to mean instead a good faith estimate of the salary or hourly wage range that the employer reasonably expects to pay for the position upon hire. Now, the legislature added the phrases good faith estimate and upon hire. Now, it also says that wages and wage rates include all forms of pay. So we're talking about things like a transportation allowance, some sort of hotel accommodation or travel reimbursement, profit sharing, overtime pay, bonuses, any of those sorts of things. They're all going to be included as wages. Now, in terms of the statute of limitations, And when a cause of action under this law actually arises, the legislature has provided some helpful guidance. So first of all, the cause of action is going to arise at the time an unlawful compensation decision is made, or when an individual, an employee, becomes subject to an unlawful compensation decision or practice, or when they are affected by that practice or decision. So here's the kicker: including each time wages, benefits, or other compensation is paid. So this goes back to the Ledbetter decision that was issued by the U.S. Supreme Court several years back, saying that when you have a compensation decision that is discriminatory, you're paying women less than you're paying men for the same or a similar position, they have what's called the continuing violation, right? So every time you give them a new paycheck, that new paycheck is a new violation because they're still being paid in an illegal way. So that's a helpful thing for us to know. When does the cause of action accrue? That's the lingo that lawyers use. In terms of the statute of limitations, it was 2 years from the last date that the cause of action occurred or accrued, and it's now 3 years. So the statute of limitations is now going to be 3 years instead of 2 years. And that's 3 years from the last bad act, which in this case could be the last paycheck, regardless of whether the violation is willful. It doesn't matter if the employer meant to do it, they tried to do it, they wanted to do it, none of that matters. It's now 3 years. And there is a 6-year term, if you will, of damages. As the employee, you can recover a relief or back pay damages for the entire period of time during which a violation exists, not to exceed 6 years. So you have to bring a claim within 3 years of the last bad act, but you can go back 6 years for your recovery. Okay, these are all things that were unknowns, frankly. I mean, we were all guessing, except we did have the 2-year statute of limitations under the old law. But the rest of these things are really pieces of information that we needed to get, and that I think is going to be helpful for employers to ensure that we are all staying on top of it here. Now, a lot of you have asked me questions about these pay scales, right? And what do we actually mean by a pay scale? And I know it's tough. I mean, when we advertise for positions in our law firm, our administrative positions are a little easier because they're all generally within the same basic framework. But our lawyers can range by, over $100,000, depending on what their level is and what they're doing. So when I advertise for a job, because we're a small firm, we don't always say, well, we want a mid-level or we want a lower level attorney or we want a more senior attorney. We just want to see who's out there and see if they're going to fit into our team. When we publish a pay scale, it's a pretty broad pay scale, but it really is a good faith estimate of what we expect to pay for that position, depending on who applies for it. So what are the things you should be doing to comply with these requirements of SB 642? First of all, you got to look at your policies and procedures, as always. So as many of you know, because you participated, Julia Insel, one of our lawyers, one of our senior advice lawyers, did a webinar last week on employee handbooks. And she talked a lot about updating your policies and procedures and making sure that you look at all these new laws and you update your policies, your documents, your templates accordingly. If you don't do that, you can end up in a situation where you're behind the 8 ball, right? And you're telling folks that you're doing something that is incorrect, right? Or you're not doing what you should be doing. So I want you to look at your policies and your procedures. Okay, the other thing I want you to do is think hard about your pay scale. Obviously, there are going to be some situations like with our law firm where when we're looking for attorneys, it's going to be a pretty broad band. But for other positions, you're going to know within, a couple $1,000s. Don't advertise this huge pay scale if you really can narrow it. You have to do this in good faith. Also remember that you're going to have to think about how to do your reporting if you are subject to reporting in this area. You want to make sure that you understand what the requirements are for reporting. That is really going to be a requirement only for the larger employers, but that's a big responsibility that you have annually if you have 100 or more employees. So you do have to make sure that you are paying attention to those requirements as well. Also, if you're doing internal audits, as many of you know, Elena Schroeder, another senior advice lawyer in our firm, she does an amazing job at audits for employers. And this is going to be a new area that she'll be looking at. She's already been looking, of course, at compensation and pay equity, but we're going to have to look a little more closely at the scales, the pay scales, and how you're actually doing your job postings. So that information should be included in your own internal audit. Also remember that this is a great opportunity to review your pay structure generally to make sure that you are paying people appropriately, that if you have brought people on recently and paid them more because you wanted to get them, right? You needed them to join you and maybe you paid a premium to get them. You may have a situation now where people who have been very loyal to you, who have worked with you for a while, who have done a great job, they're not getting the same compensation. And if they find out about that, and remember, employees are certainly allowed to talk about their pay and comp. You can't prohibit that. So if they find that out, they're going to feel very disrespected and very undervalued. So this is not only a legal issue, this is also a morale issue. You need to be looking at your pay structure, at least on an annual basis, to make sure that you are paying people fairly, that if you, for example, gave someone some sort of a bump because they took on additional work during a particular time, now they don't do that additional work, but they still are getting increases. It may be time to flatten it out for a year and say, listen, you're no longer doing that part of your job, so we're not going to give you a bump this year. It's not because you've done anything wrong. We just have to keep you in line with everybody else. So again, that is also a morale issue. Nobody wants to get a pay cut, but sometimes a pay freeze, something where the comp won't be moving for, let's say, a year, goes over better. It just depends. You've got to know your workplace. You've got to know your people. You have to know how these decisions can impact them. But the big picture is the legislature is very focused on pay equity, right? On pay fairness and on pay transparency. So this is an area that you want to have on your to-do list. You want to be thinking about how you're going to ensure compliance. You want to make sure that you are taking the steps necessary to encourage managers and supervisors to understand compensation, to make sure your employees are aware of how you make compensation decisions. Transparency is really important. And when you are not transparent, it is very hard for your employees to trust you. So take some time, get this on your to-do list, make sure that you really are ready for this new requirement, which is, of course, effective on January 1, 2026. Thanks for joining me today, everyone. Thank you for doing such a great job and for putting up with us every week. Don't forget to send in your ideas, your comments, your perspectives. I always love to hear them. If you've got ideas for topics, love to hear those as well. We are very grateful for your partnership, and we look forward to continuing to work with all of you in the new year. In the meantime, have a wonderful rest of your day, and I'll see you next time. Before we sign off, I want to remind you about our 25th annual legal update. We have 3 sessions. I want to make sure that you sign up for them before they fill up. We're going to talk about all the new statutes for 2026 and all the relevant court decisions, as well as any other agency developments. So go to our website, sign up, space is limited. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.